panel discussion of the topic recognizing and addressing racism in administrative law. We want to thank the section of Administrative Law and Regulatory Practice of the American Bar Association for helping us present this panel. But at the outset, I want to remind everyone that the views expressed by the speakers represent the opinions of the panelists, not the views of the American Bar Association or the section of Administrative Law and Regulatory Practice. This panel has a rather long pedigree in some ways. I think many of us noticed that in 2017, Richard Rothstein published a book called The Color of Law, which documents how the federal, state, and local governments impose segregation through zoning systems, the administration of public housing, the tax system for, accounting for loans and tax incentives for constructing housing, and how police and prosecutors enforced the full power of the, brought the full power of the administrative state to bear to maintain racial segregation and these policies in administrative programs. Since the summer, since earlier this year, 2020, the increased public protest activity that emerged regarding the impact of law enforcement actions directed at people of color has inspired the section of Administrative Law and Regulatory Practice to try to address these issues more directly using the cadre of scholars that we have and practitioners who think about how the implications of administrative law in practical realms. In addition to the activities regarding law enforcement, even before that time, the COVID-19 epidemic and its well-documented disparate impacts on communities of color and low-income communities also has brought front and center some of these issues about how the administration of government and the legal rules that relate to how programs are administered can either alleviate or perpetuate societal disparities. I want to thank, before we get into the merits of the panel, in particular, Catherine E. Kovacs, Katie Kovacs, who is the co-chair with me of the section's diversity committee, who actually inspired us and was relentless in encouraging the section to address these issues through a lot of its different program activities. So specifically, the section has sponsored a symposium on racism in administrative law in the notice and comment blog that the section produces in collaboration with the Yale Journal on Law and Regulation, which attracted commentary from more than 24 authors. In addition, the section's newsletter, the Administrative and Regulatory Law News, sponsored an issue on the same theme. So today we are pleased to have with us 3 distinguished scholars and practitioners to talk about some of these issues. 2 of them have written for some of these symposia that I mentioned earlier. And one of them is very active, a former senior official in the federal government who was involved in some of the current issues of the day regarding racial disparities. So I'm going to give very brief introductions to these 3 speakers, and then you have their biographical information, I think, in the program promotional materials. And so if you want to know more about them, I'll ask you to refer to those materials. And I'm going to introduce them in alphabetical order. First is Bernard W. Bell. Bernie is a professor of law and the Herbert Hannock Scholar at Rutgers Law School. He is a constitutional law expert who specializes in property and privacy law. And he has written for the Notice and Comment blog. And I think he will talk about some of the issues he raised in his piece for that publication. Next is Steph Tai, who's a professor of law at the University of Wisconsin Law School. And she focuses her teaching interests in administrative law and environmental law, food systems law, and environmental justice. And she, in exploring those fields, she's able to take advantage of her background in chemistry as well as her law degree. She also has worked as an appellate attorney in the Environmental and Natural Resources Division of the United States Department of Justice. And then finally, we have John Taylor, who is president and a principal of Greenleaf Health Incorporated, which is a leading Food and Drug Administration regulatory consulting firm. He has more than 28 years of experience working on food and drug related issues at the FDA and in private industry. He currently leads Greenleaf's Compliance and Regulatory Affairs Group, but prior to that, he did several tours with the FDA, including being Chief of Enforcement and having very senior positions in the Commissioner's Office. So welcome and thank you to all the panelists for being with us today. So I want to start the conversation by inviting all of you to talk about the pieces that you wrote, or in John's case, some of the work that he's doing in the current environment to address issues of disparity that have come up with the COVID-19 situation. So Steph, let's start with you. And your piece was about how federal grant and funding decisions sometimes reflect implicit and systemic bias. And so why don't you tell us a little bit about how you came to that subject and what your concerns are about that area of government activities?
Thanks. Yeah, so it comes from two different areas that I pay attention to. So one of them is agricultural law and food law. And there was a lawsuit, there was regarded as one of the sort of biggest civil rights settlements in the United States that we never really talk about, which is there's actually a number of different lawsuits, but the one that I focused on, the two I focused on were the Keeps-Eagle and Pigford settlements. These were settlements, these were cases brought by Black farmers and Native American farmers against the USDA for basically having huge racial disparities in terms of providing loans to these farmers. And many of these farmers were driven out of business as a result of this. What's interesting is that I was thinking about this in terms of other areas of funding as well. So there's other areas of funding. NIH in 2011 had been subject to an expose where also it was revealed that they had been quite discriminatory in the sense that there was a huge disparate impact on who they were funding in terms of grant applicants for research. And so in both of these areas, one was outside litigation pressure, one was instead internal kind of shock and some kind of agency will to address things. In both of these areas, agencies had to address, right, this kind of disparate funding. And it made me think, well, as a sort of administrative law professor, why is it that we have such a weird way of addressing it in the APA? That is, for all of these types of decisions, right, it falls under informal agency decision-making, right, which the APA says, Administrative Procedure Act says that, it's subject to an arbitrary and capricious kind of standard. And you would think that huge racial disparities, right, are de facto arbitrary and capricious. But the APA doesn't really create the tools to deal with it, right? The APA limits these cases to a more individual point of view versus these kinds of systemic reviews. So we have to rely upon all these other kinds of tools. But on its face, right, there seems to be a contrast between the language of arbitrary and capricious and what actually can fall under it. And so I wanted to explore that and tease that out with my piece. So that's kind of how it came to come. And I think we're seeing some of the results of that now in other areas of funding. For instance, under the CARES Act, with the Paycheck Protection Program, people are already seeing huge disparities in what businesses get loans or get money. And I think that it'll be an interesting way to explore how the agencies distributing funds either do or don't address these racial disparities and what tools they use to do so, given the lack of force that the APA has.
And of course, some of these latter things with the CARES Act, relate to other kinds of structural barriers like access to banking services and those kinds of things that, were part of Richard Rothstein's discussion in The Color of Law. Yeah. Bernie, what about you? I know you have taken this approach of really directly addressing some of the theories that undermine different approaches to administrative law. And one of them is that some scholars have embraced kind of a liberty point of view about how a lighter government touch can enhances liberty, and inherently greater regulatory programs or intrusions. Intrusions is kind of the wrong word, but greater regulatory efforts interfere with liberty. And you've criticized that point of view. Do you want to say a little bit about that and how you wrote about it in your piece?
Yeah, sure. So generally in thinking about and writing in administrative law, I have generally, in many ways, looked at it as procedural. I know procedures have consequences, but I've looked at it as procedural as opposed to through a race lens or critical race lens. And the events of the summer really served as a prompting or catalyst to get me to ask the question of, well, why does administrative law seem to be colorblind? And really the piece, the piece in some sense is really ask questions for which I don't purport to have the answer. So in some ways, the most powerful part of the piece is not the answers that I provide, but the questions that I raise. But more particularly, Renée, in the part of the piece you reference, is that a major trend, a major part of administrative law these days is really a challenge to agencies and their power. So agencies are problematic because they combine different types of powers that should be separated. So they combine the executive, the legislative, and the judicial, and that's problematic. Or they have too many investigatory tools. It could be too intrusive in terms of penalizing regulatory entities. Or they're not sufficiently tied to the President of the United States or perhaps other heads of branches. So in some ways, the kind of upshot of this attack is that in various ways, administrative agencies are really very powerful leviathans that kind of dominate regulated entities. And essentially, my piece points out something that I've kind of thought about outside of the context of race, but applies with regard to racial justice, is that there's another way to look at the problem of administrative law, right? And to look at that, you should really think again about what agencies do. And we often focus on regulated entities, right? But what agencies do is it's not the government beating up on regulated entities. Essentially, agencies are designed to protect certain vulnerable communities or vulnerable groups. It may be labor, it may be borrowers, it may be people who love the environment, and it often it involves people who are vulnerable because of race or ethnicity. And so the more you focus on the liberty of regulators and view the government as too powerful, the more you debilitate government and agencies from regulating powerful entities in order to protect vulnerable groups who in an unregulated setting are going to be the kind of repeat losers in the game. And so if you look at government agencies' performance, you begin to see that in many areas, the government doesn't, or agencies don't seem to be particularly powerful. They seem, in fact, to fail to protect the people who are vulnerable and that they are created to protect. So sometimes this is called the agency capture theory. But an example I use in my piece is the problem of railroad grade crossing accidents. And so I teach torts, and in my days of innocence, I guess early on when I taught torts, we had these cases involving railroad grade crossing accidents. And I said, well, isn't this a stupid way to deal with this? You first have the accident and then you give money or not to the person who's injured. And the administrative state has a much better way of dealing with this. There's a cooperative federalism program in which railroad crossings are evaluated in terms of the arrangement of the crossings so that they reduce the number of railroad accidents. And the federal government then provides funding for states essentially to upgrade those railroad crossings. And it sounds like a great program as it is, but in the early 2000s, there's kind of an expose in the New York Times that shows this program suffers from a lot of failures. There were so many accidents that the Federal Railroad Administration told railroads, don't report all of them. There's too many for us to deal with. And there are still lots of railroad grade crossing accidents that are occurring despite this program that would seem to have a lot of potential. So the problem there is not the agency is too powerful, it's this Leviathan that's suppressing regulated entities. It's that it's not doing its job of protecting the vulnerable. And in the context of race, I asked the question of whether the failure to make railroad crossings safe disproportionately affects poor and minority communities, right? And I don't know the answer to that question. My suspicion is that probably the crossings that are the least protective tend to be ones in or near poor communities or community, racial or ethnic communities. But that's an empirical question to do research on. So, and there's kind of a number of other things I talk about in my piece, but basically that is my concern about a major aspect of administrative law scholarship these days, is that we're really focusing on the rights of regulated entities to such an extent that we undermine the ability of the government to do what it's supposed to do, which is to protect the vulnerable. So I think I'll stop there because I've been talking a long time on this.
No, but that's very helpful, because it's really an argument about how can some of the procedural rules where you started your conversation in administrative law be used to actually give effect to the agency's mission, as opposed to thinking about the costs and the regulated entities so much, or any other kind of barriers to action. And in the railroad crossing, it seems to me there's probably enough information that the railroads have. They know how to make the crossing safe by now, or safer. And so, it's not sort of rocket science to, have the agency sort of, invite the railroads to improve the railroad grade crossings. Well, another issue that, is top of mind these days, especially with the news this week and late last week about the progress in developing vaccines to address the COVID-19 situation. The issue now is, the discussion now is about, who's going to have access to vaccines, how are we going to make those determinations? are the vaccines going to be given to the people who are the most vulnerable? How do we identify who those people are? And, really, how do we sort of triage the distribution of these vaccines, because they're going to be obviously limited in quantity at the when they're first introduced. And so, John, I know you've been thinking a lot about this, and maybe you could tell us a little bit about, what your thoughts are and what some of the challenges are in thinking this problem through.
Sure. Thank you very much, Renee. So my interest in this issue sort of stems from the sort of larger question, and that is, how do we ensure equal access to the medical and scientific innovations that are occurring now and in the future? And I started thinking about this in the early 2000s when I was at FDA, because there was an explosion of biomedical research in the late 1990s and 2000s, some of it connected to the mapping of the genome. And the question became, one, how do you treat populations better, but also how do you treat individuals better? And there are certainly, a lot of complicated questions raised there. And so that was my first time I started thinking about it. But moving to today, it's even more resonant at this point in time, because as Renee pointed out, it's widely reported, both Pfizer and Moderna, have a vaccine. Both of them have high efficacy. And the open question is, once FDA makes a decision that they are appropriate for authorization and usage, how are they going to be distributed? There's actually two facets to that question. One is whether or not the trials have included broad population, and whether or not those participants are part of the minority population. The answer to that is both are working on it. Moderna actually slowed their clinical trial in order to boost minority enrollment. Pfizer has made that a priority as well, but challenging in both contexts, and we can talk about that later. So what happens is FDA is going to have to make a decision as to whether or not these should be authorized for broad usage, and then that goes to CDC. CDC has an advisory committee, the Advisory Committee for Immunization Practice, also known as ACIP, and they are the ones vested in determining how the vaccine should be distributed. And as of right now, they are making sure that healthcare disparity is a central component of their decision-making process. Ostensibly, the goal of their decision-making is threefold. One is to decrease death and serious injury to the extent possible. The second is to reduce the burden of health disparities, and third is to decrease disruption to society. As part of their strategy to reduce healthcare disparities, they're essentially at this juncture looking at potentially four categories. The first category is pretty straightforward, and that has to do with healthcare workers. But the second, third, and fourth categories are specifically targeted towards trying to address the healthcare disparities that have become all too obvious in the context of this pandemic. So the second area that they're looking at is whether or not to immunize essential workers. By essential workers, they mean service industry, essentially workers who are not as highly paid, who actually have to have contact with the population and therefore at a greater risk for contracting COVID, as opposed to myself, who works in a white collar office and can limit one's exposure. And again, one of the facets behind their decision making is to reduce healthcare disparities. The third category that they're looking at, and this is really important, has to do with patients who have certain comorbidities. Essentially, they call them high risk adults. One of the things that was readily apparent early on in the pandemic, as early as late March, is its impact on minority populations. At that time, I think it was as early as late March, both in New York and then later in Chicago, it was becoming quite clear that a vast majority of folks who were contracting the disease had one or more comorbidities, and that the minority populate, and that these comorbidities were present in the minority population, and this contributed to the difference in its impact on minority populations versus populations of European descent. So CDC, as you can see, is very much targeting their strategy to address that issue. And then the fourth category has to do with adults who are 65 years and older. Again, an area that not just focus on race, but disparities from an age and gender context, an attempt to really try and make sure that as a part of the strategy at the outset, these folks are protected. The complicating factor here, though, and this relates to another part of the discussion, is this advisory committee is largely going to be working off the decisions made by FDA and FDA's advisory committee. And the reason that's important is because the FDA advisory committee is going to make their decision based on the data that is present. And as I alluded to earlier, there has been a yeoman effort to increase minority population in these studies, but FDA is still going to have to make a call with a patient population that is not as representative as one would like. And that's all impacted by the fact that this is a product that everyone is going to take. These questions of health disparity and unequal treatment are resonant in many discussions, but here, this is a product where the intention is everyone's going to take it, and therefore understanding its impact on various populations, including minority populations, is going to be very important. Once FDA makes that decision, that's when it flips to CDC and they determine how to distribute it. And that's just for right now. That's just for the purpose of the early usage of these two vaccines. Down the road, the same process will occur not only for other vaccines that come to the forefront, but they will also impact decisions regarding the broader distribution of the vaccine when there is a larger supply, i.e. a distribution that's broader than the four categories I've talked about. But you can see there's two issues at play here. One is, are the underlying clinical trials representative? And if they're not, how do you still make the cost-benefit analysis underpinning the need to authorize? And then from there, how do you take that data and make the proper allocation decisions so that, again, you're able to actually reduce the healthcare disparities that have been present throughout the pandemic? So, Renee, in the work that I do, we spend a lot of time helping companies work on therapeutics, diagnostics, and the vaccines that are being used as part of the pandemic. And this is just an issue of resonance that I think will obviously continue after the pandemic is over. And I think, if anything, I think having to deal with this issue in the context of the pandemic might give it better framing and might lead to better solutions than had been possible prior to this tragic event.
Right. So it's nice to think about the day when the pandemic is under better control.
I was being optimistic.
So that we're all not sitting talking to each other on Zoom all the time for conversations like this one. But the other issue, John, I'll stick with you for a minute, is, it's, the government recommending that people take the vaccine, approve the vaccine, and then take the vaccine, having sorted through some of these issues that you've talked about as best as possible, with the data that are available. But then it's the willingness of people actually to take the vaccine. And the participation of people of color in clinical trials has been problematic for a lot of reasons due to abuses in the past that are very familiar. And then this is kind of carried over now into the current environment when there is skepticism about the vaccine, partly due to the kind of Operation Warp Speed aspect of it. Sometimes you can't rush the baking of the souffle, right? Probably not such a great analogy, but anyway, so what do you have any thoughts about that and how to address that problem?
Yeah, so Renee, actually that problem is inextricably intertwined with the larger issues relating to, even before you get to the question of whether or not to take the vaccine, those questions are also present in regards to whether or not you want to participate in the studies themselves. So one of the things that the Food and Drug Administration has done recently, just in the last couple of weeks, is they issued new guidance that's trying to promote greater inclusion in these clinical trials. And the things that they focus on are adjusting the eligibility criteria in order to incentivize more minority participation, looking at how enrollment can be improved, and also looking at whether there are clinical trial strategies that can be used to drive greater participation. In the context of enrollment, that's where, Renee, the issue that you mentioned comes into play. One facet of enrollment is just simply distrust of the medical community. That is very much a residue of Tuskegee and other abuses. There are other facets as well. One in the context of many times these clinical trial sites are not in geographical locations that make it easy for minorities to participate. Another factor is just being able to get transportation to go to these sites, or the fact that if you're a minority and you are a certain income level, you can't take off the day to join a trial. So there's a lot of factors in play here that reduce minority participation in trials, but also sort of feed the larger distrust about taking the vaccine. But I think at the end of the day, what the companies and the government and patient groups are trying to do is provide better education. So BIO, which is the Biotechnology Innovation Organization, it's actually headed by Michelle McMurray-Heath, who's an African-American physician, very, very smart and talented, is trying to work with National Medical Association, patient advocacy groups that deal with the African-American community, essentially work with the community to better educate the population so that not only they're willing to participate in the trials, because there are more trials ongoing. Those are only 2 of several vaccines that are being tried, but then also educate people about the benefits of taking the vaccines once they're approved, and helping people understand the risk-benefit analysis, and making sure, because what's actually been picked up in some of the studies is that right now the African-American community is also distrustful because they feel like the vaccine's being pushed through for political reasons, is something that's been picked up by a couple studies. So the idea is to educate folks on the risk-benefit analysis, the process that's been utilized, the scientific rigor that's gone into it, so that not only are people willing to take the vaccines when they are approved, but also so that people are willing to join the ongoing studies that are being done in connection with some of the other vaccine candidates, because we need all those candidates so that we can not only help with the US population, but the worldwide population.
Can I
So,
just
go ahead, Steph.
because John brought up this point about people being reluctant to participate in this, and I think that that's also partly a result of that long-standing history of grant funding disparities coming from the NIH in terms of medical trials and other kinds of studies. If minority primary investigators are getting funded at a lower rate, there's going to be less studies that are conducted with minority populations necessarily in mind of the researchers. And so that long-standing history, I suspect, exacerbates some of the dynamics that John has been talking about.
Yeah, I mean, to Steph's point, these issues aren't new, I'm sad to say. I believe it was 1993 where Congress actually asked NIH to increase its steps in regards to including both women and minorities in clinical trials. And Steph alludes to the grant process. And I think in 2014, the numbers showed that there was an increase in the enrollment of women, but the enrollment of minorities still had not increased very much. I think it was maybe a 3% increase, which is pretty sad over an 11-year trajectory. And I do think that Steph is right. And I think that also extends to other facets of this discussion. I think more minority physicians, minority researchers, minorities on the advisory committees, minorities who in the biotech industry, quite frankly, I think having those different and diverse voices, as well as boosting women's participation in those areas as well, I think would go a long way again towards helping to address some of these issues. So I definitely agree with Steph that is I think a factor as well in the slow progress that's been made here.
So I want to move on from this topic and address some other issues in a minute. But meanwhile, there was a really interesting question that's highly relevant right at the moment from the chat, which is maybe, John, you could address the diversity of some of the advisory committees that are going to have input into what these government agencies recommend about the use of the vaccines and the distribution of vaccines.
Now, it's a fair point. The rules surrounding advisory committees seek to encourage broad inclusion. but that simply is not necessarily the case for a myriad of reasons. FDA struggles with their advisory committees for a myriad of reasons. One, a conflict rules, not necessarily having a minority population to pull from that's as fulsome as a population of European descent. So that I think is an issue. I will say that I don't necessarily see it as an issue in regards to decision making, because I think in both in the case of the FDA and CDC, science at the end of the day does drive the decision making. But I think the overall discussion, debate, and attentiveness to these issues, I think, would be enhanced by broader participation. That being said, the FDA advisory committee that was held at the end of October as a precursor to the advisory committees that will look at the Pfizer product and the Moderna product separately, did very much focus on the need for increased robustness when it came to minority participants in the trial. So I guess my point is, I think that greater diversity is something we should focus on, but I also haven't seen the lack of diversity in this context impede people's ability to, one, identify the issue and identify the need to address and strengthen the structural weaknesses that have led us to where we are today.
All right. So one of the, obviously the conversation we've been talking about is, really focusing on, how should and how can government entities take into account race better in their decision-making processes. So one of the, problems or barriers that has arisen is that the Supreme Court has really increasingly embraced a colorblind theory regarding race-conscious actions in terms of government action, hiring employees, maybe selecting people for advisory committees, selecting contractors, admissions to colleges and universities. We have the recent First Circuit decision late last week on the in the Harvard case. So what kind of impact does this trend have on efforts of administrative agencies to address race more broadly? And is it possible or realistic for agencies, really to engage in these data collection efforts and these, more racially focused strategies with that background in the law? So I don't know, Bernie, maybe start with you on that.
Sure.
Question.
So I do think that the colorblind theory in constitutional law does make it more challenging for agencies to focus on racial justice issues, to focus on issues where there are disparate impacts based on race and ethnicity. Because if you can't take that into account in considering what your actions are, then it makes it hard to address those issues directly. So then you have to start using proxies, which may to some extent map out onto the problem, but not completely. So trying to deal with people who are poor and increasing their opportunities is not the same thing as trying to deal with racial justice and deal with people who are disadvantaged because of race and ethnicity. So I think that does pose a problem. I think some of the issues that administrative agencies can deal with are not the types of issues that the Supreme Court has been most focused on as far as colorblindness. So admissions of individuals to institutions of higher education, hiring of individuals for jobs. I think the colorblind theory poses challenges in that context. But maybe if we start to think about situations where the problem is a disadvantage for communities, maybe there is a bit more play in the joints to get out of the colorblind theory of constitutional law. So for instance, with regard to reapportionment, the laws, constitutional law is of course a little bit of a mess there, but it does allow much more flexibility in terms of race-conscious line drawing with regard to legislative districts. And that's because you're looking at communities of interest rather than the kind of one individual versus another individual scenario. So I think, for instance, with regard to what we've just been talking about with regard to distribution of the vaccine, right? COVID in particular is a communal problem. The likelihood of catching it to some extent is to some extent dependent on the community in which you live, because it's spread through contact, spread through communities. And in addition, there may be part of these health disparities may be attributable to problems in terms of locations of medical practices, access to healthcare in general. And that's in some ways community-based. There are many people in a community that share that. And you actually don't necessarily have to be African American or Hispanic or minority to share in those same problems if you live in that community. So with regard to a kind of broader prioritization of the distribution of vaccines, the government probably, well, the government can certainly say, we're going to look at communities in which the prevalence of COVID is greatest. And that actually will probably map out onto communities that have a high representation of people of color. But the FDA or the government may also be able to say, look, in this context, we think we can focus on racial and ethnic disparities, and we're going to look at communities that are largely communities of color, and that's going to be one of our priorities. And I think because you're talking about it in terms of community rather than individuals, that might give you a little bit more flexibility to take a race-conscious approach. I think also one of the issues, of course, is if you're looking at disparities, you have to know what the data is. And I think in some ways, John actually, and probably Steph can talk a little bit more about this than I can. But for instance, if an agency is distributing grants in a way that is discriminatory, if you don't have data that shows the racial ethnic background of the people who are the applicants and the people who are the recipients, you're not going to really be able to figure out whether there is a disparity without some extraordinary effort being made. And in some ways, it is understandable why you wouldn't want people identified by race and ethnicity when they're applying for grants, because there is still racial bias. And so you don't really want to feed into that. So you're kind of stuck between a rock and a hard place where you have to be subtle about being able to collect the information, but not have that information influence people while they are making decisions. So I think certainly information collection is something that I think the Supreme Court has not interfered with, and actually is critical to ensuring just equal treatment, which is the focus, I guess, of the Supreme Court's jurisprudence right now. So I certainly think that by thinking about things in terms of community and thinking about things in terms of making it easier for people or government agencies to know what the disparate impact is with regard to race and ethnicity, I think those things can still be done, even though in general, we're talking about a kind of colorblind constitutional law. But of course, there are new justices on the court, and who knows whether they will buy further into this colorblind theory, which will even make some of these other efforts that I'm talking about more difficult.
So this thread that has emerged in our conversation about the impact on communities and groups, as opposed to just sort of taking individuals one by one as they encounter a problem in the world or, encounter a government agency. I want to get Steph to talk a little bit about this because of the work that you've done on environmental justice and environmental policies. And I know that I received a chat message from one of our administrative law section colleagues, Peter Strauss, and his piece in the for the blog, the notice and comment blog, he wrote about the Overton Park case, which is, one of the iconic, cases on, the arbitrary and capricious standard for review of informal decision making. And the point of his piece was that, while, everybody's happy that Overton Park didn't get the interstate highway built through it, that the alternative route actually had an impact on a largely African-American community. I hope I'm getting these, remembering these facts correctly from Peter's piece. So how do we, and part of, this issue was, not mentioned in the Overton Park case, not really part of the kind of popular lore when we teach this case. So how do we deal with this problem of groups in some of these areas of the law, Steph?
I mean, I think part of it is what I was trying to talk about in my piece, which is that the arbitrary and capricious standard has been applied to individual decisions. And so we never see the big picture kind of thing because the inquiry is directed towards that. And so maybe the response would be to have an additional layer, right, of agency review over the impact of all of their decisions together versus individual decision by individual decision, which is kind of what the APA creates this sort of narrow focus towards. It would have to be sort of from an act of will by an agency because there's not so much of a strong legal compulsion for it. I talk a little bit about how difficult it is to raise Civil Rights Act cases in my paper. And so this would have to require additional agency design, but I think there are ways to do that. For example, after the NIH found the funding disparities, some of the things they tried to address, and I think this gets a little bit to Bernie's suggestion, is they tried to also not just focus on color blindness and reaching sort of, scrutinizing individual grant kind of decisions, but also focusing on infrastructure as well. For example, infrastructure like creating more mentorship for minority applicants for grants, creating and removing some barriers too, like, right, having, there are certain kind of requirements for grant applicants to be in certain kind of tier schools, which might be less, accessible to sort of minority young researchers. The similar thing too with the PPP loans or PPP grant funds, that there's been a lot of suggestions that just having a requirement for existing kind of lending from banks actually ends up excluding, right, seemingly neutral characteristics ends up disparately excluding from application a number of Black and minority owned businesses. And so there's a way of addressing, sometimes teasing out certain kind of factors that end up being quote unquote neutral, but inherently leading to discriminatory impacts that we can do. But as Bernie says, you need to be able to have some transparency with the data to be able to figure out what those kinds of colorblind, in a way, colorblind ways of addressing disparities can be.
Right, so Bernie, you've floated this idea of maybe having a requirement for a racial impact, an assessment for agency policies, rules, actions, similar to the NEPA environmental impact statements, or, there's a whole laundry list of them that agencies are required to go through now when they consider rulemaking. How would that work? Because this is sort of building on what Steph is talking about.
Sure, absolutely. And I guess this is the point where I'm really not speaking for the section, because I think the section has come out against having additional impact statements. But I think there's some topics on which you reach a certain point where, despite our general aversion, perhaps to impact statements, this would be justified. So it would work kind of like NEPA essentially. So when an agency is taking an action, either structuring a grant program, deciding how to distribute a vaccine, deciding the route a highway should take, one of the analyses that would have to be done is, does this have a disparate impact on racial or ethnic minorities? And as with NEPA, The point would at least be for decision makers to have that information and be able to make an informed decision based on that information. It wouldn't necessarily mean that the action wouldn't be taken despite the disparate impact, but at least that would bring in people into the decision-making process, because generally one of the other reasons to have an environmental impact statement is that once it gets distributed, then various people in the area see that, and then they kind of are brought into the process and can make their preferences known about the government action. So this would be a way of increasing the participation, hopefully, of people of color. And kind of one of the themes in the blog post was a kind of focus on participation and how the way participation is structured tends to disadvantage communities of color as well as others. And so that would address that. And so the question is, in some ways, once you know about a disparate impact, if the agency decides to take an action or to alter its action because of the disparate impact on the community, is that going to create a difficulty for you with regard to the Supreme Court, because now it's not a colorblind decision? Because of what I said before, I would think one could be okay on that would not be unconstitutional to take into account general impacts on racial and ethnic groups. But I suppose that would be an increased risk of explicitly setting out, the fact that you are looking at race and ethnicity and making decisions based on potential impacts. But that's the basic idea, just for us to be more conscious of, or agencies to be more conscious of, and think about more the disparities in terms of race and ethnicity that many policies actually accentuate and sometimes ignore.
Well, if you take, this sort of status quo as the baseline, which has, hard baked in systemic racism in a lot of areas of life, then, the policies inherently are going to just build on that same platform. And there's a risk of doing that unless there's a real conscious focus. But your last set of comments had this very optimistic view about bringing people into the process of the participation process, and commenting on proposed regulations, guidance documents, actions that are going to be taken in a community. And so, what do we think about the structure of the way administrative law either invites or discourages people into the process? Obviously, well-organized business interests or whatever are better situated, right, to engage in some of these participatory activities. But are there ways that we could sort of rethink that process or encourage a different approach to include, to entice and invite more people in, and to feel that, so that they would feel like their comments were actually taken into account? I mean, I wrote about this a little bit in my piece for the blog, as did Bridget Dooling, who's a GW professor, about, our efforts to participate in, a couple of rulemaking processes. And, on the one hand, you don't want the agencies to kind of reflexively have to respond to comments, because some of them are not valid and some of them are, not reasonable. But on the other hand, it is very easy for the agency to say, well, you raise an interesting point, but, we're not doing that here. We're not talking about that now. And, maybe later at some, future hypothetical time, your concern about race or racial impact will be brought to bear, or we'll think about that again. So how do we think about that? And how do we encourage people to participate? I don't know, Steph, if you had anything you wanted to say, and then I'll come back to, oh, John. Well, John, why don't you go first and then.
Yeah, so I think it's very important. And Renee, even before we get to your question, I think there's a initial question. I think Gwendolyn McKee wrote about it in materials, which is I find the Federal Register and the whole notice process to be somewhat inadequate. It is obviously statutorily mandated. It is judicially recognized, but both during my 2 stints at the agency and as a outside stakeholder, and her article really made me reflect on this again, especially because it cited FDA. But the truth of the matter, and when when Bertie was discussing his last answer, I don't think the Federal Register notice. I think it's inadequate for eliciting the kind of comments that would actually lead to the type of discussion debate that would drive the kind of policymaking we're talking about. I think it is, in my humble opinion, at least in the healthcare field, it is clear that if you are a powerful company, trade association, even a powerful patient group, that there are haves and have-nots. You have a certain amount of economic acumen or resources that you can follow the Federal Register and be cognizant of all the notices. And for FDA, there are a lot of notices that go out. And then from there, you're able to make a strategic decision as to how you comment, which also invariably involves a set of circumstances where if you have the money to hire a savvy law firm or a communication specialist, you're at advantage. It just is an imperfect tool, in my humble opinion, unless augmented, for reaching the vast populations who actually have a stake in some of the issues that we are discussing. So, one of the things that FDA's tried to do, and in the article, it talks about how the Office of Women's Health was eliciting comments on the health priorities for women, and that was the only place where that notice was mentioned. There were not other attempts to use other mechanisms to spread the word. In fairness to Office of Women's Health, they've actually do use broader strategies. I don't know why they didn't do so there, but the Office of Minority Health and Health Equity specifically, and using again the pandemic as a backdrop, has tried to find additional ways to push out these Federal Register notices so that people are aware of these opportunities to comment and be a part of the process. I still think it's woefully imperfect. I still think it sort of fosters these haves and have-nots. And I just think it would be interesting if someone had the time to study the reach of the Federal Register when it comes to minority and disadvantaged populations, and then use that as a way of trying to figure out how to improve its reach so that there can be a broader pool of participants. And then it gets to your question, which is, how do you craft the agency process so that once a larger number of people are participating, they feel like their opinions are actually being heard, even if they ultimately are not considered as part of the ultimate decision making. How do you incentivize people's participation by making them feel like at least their ideas were considered? And I think especially the latter issue is terribly important, but also the former. And I suspect, again, in some cases, by not addressing those serve as an impediment to dealing with some of the disparity issues that we're talking about.
One thing that, sorry.
No, go ahead.
One thing that comes to mind, and someone had asked about advisory committees in the past, and I'd done some research comparing different advisory committee structures in the US and in the EU in terms of requirements. And the US is, as John mentioned, it's got all the Federal Advisory Committee Act and like the membership and stuff, and there's requirements to vaguely be comprehensive, but there's nothing in terms of outreach about what they're doing. There's a sort of passive way for an advisory committee to receive information should anyone want to comment on it. But much like the Federal Register and notice and comment, it's up to the people to do so themselves. And usually it's people who are more well-resourced and more savvy to do so, a lot of times leaving out minority communities. In the EU, there's actually a requirement for outreach in advisory committees in making these determinations. And these can include, outreach to communities they specifically want to make decisions that address. So I think that having something like a bit more of a push to the to decision makers versus just a sort of passive kind of thing can partly address some of these, to have, to actually go out to minority communities and sort of solicit their opinion versus just sort of waiting for it to be passively received.
Renee, may I add, so to Steph's point, there's going to be at some point a reckoning where there's going to be a deliberate evaluation of the lessons learned as a result of the pandemic. One area that I think is potentially positive is the issue that Steph mentioned, which is both for, it's complicated because on one hand, one might argue that there was a stifling of information that was provided to the American public in the context of the pandemic. But in other ways, there has been an increased effort to promote transparency. And to Steph's point, the agency for that advisory committee that I mentioned at the end of October, they used a myriad of different steps to make people aware of that advisory committee, because that advisory committee was meant to be educational. It was meant to explain to the world the process and the safety and efficacy decisions, so that when these future advisory committees that essentially were going to be decision-making in nature were held, the broader populace understood and could figure out how to participate. My point is, a lot more guidances have flowed from HHS and specifically FDA, calling people's attention to various, not only advisory committee meetings, but other steps in decisions that are being contemplated in the context of the pandemic. And my hope is that the success of those steps is considered, and they become broadly applicable once the pandemic is over, in order to achieve some of the goals that we're talking about. So to Steph's point, there is undoubtedly more that can be done to increase outreach and education and notice. And I'm hoping that some of the things that have been tried in this pandemic are not forgotten, but instead are built upon as part of broadening and strengthening the ability to increase people's participation in these important processes.
There are a lot of, John's point about, the pandemic actually demonstrating to us that we actually can change the way we do some things and for the better. And hopefully some of these things will stick around even after the pandemic passes. I'm thinking about, access, telemedicine, which, raises all kinds of provide issues, but it also has this big access promoting component to it that we should not lose when the pandemic goes away. There was and then there, this issue of, who knows that there's an opportunity to participate and how do they get their voices heard, is one that came up earlier in the chat, at the very start of this conversation about, this whose voices are, actually resonate in the bureaucracy. And the example that was in the chat was the kind of, turning a blind eye to the sickle cell anemia patient population in the early days. And then, taking the Black Panthers actually called attention to the issue, and the government's like, oh yeah, maybe we should think about what we could do about this significant health issue that affects primarily the African-American community, or maybe even exclusively. So the question is, really, how do we deal with that problem of actually, getting the bureaucracy to listen? And isn't it somewhat in tension with this other competing trend that Bernie alluded to a little bit in his preliminary comments about, the executive having kind of control over the executive branch and being able to advance an agenda? So, how do we accommodate these different directions?
Well, I think so. I'm going to use bio, and there are two prominent African American women there who are doing a lot of this work, including the new CEO. But what they are doing is they have been trying to empower groups and better educate them on how to participate in the process. So whether it's community Black churches, it's trying to encourage folks to band together to increase their influence, creating consortia, centers of influence that otherwise were not in existence, in order to make it more difficult for the government to not pay the requisite amount of attention to these issues, I think is one way. I also think, and this seems overly simplistic, but I think, as we discussed earlier, increasing the number of minority physicians, members of industry, just having creation of additional voices, however you do it. Steph mentioned researchers. industry participants, stakeholder groups that focus on things like sickle cell anemia as opposed to maybe some of the other diseases. And not one over the other, but my point is, broadening these patient advocacy efforts so that they are also involved in advocating on behalf of a broader array of diseases that maybe primarily impact the minority population, I think is one way to do that, Renee.
I don't know, Bernie, did you want to?
Sure. So, I mean, I agree with John's initial point that I think it's kind of unrealistic. If we're thinking that individual people who don't have legal training, have full-time jobs and responsibilities, are going to effectively comment through the Federal Register in response to a Federal Register notice, I just don't think that that's a realistic assumption. So part of how this works, I think, is by what John was just talking about, which is that we have public interest groups or other groups who do have the ability to have lawyers or people who can be much more effective in advocacy on behalf of a group. And I certainly think it'd be great to expand the number of groups like that to encompass more interests. I think that would be helpful. But I mean, unless we're talking about a local decision that's affecting like a local neighborhood or something, I'm just not expecting that you're going to have a lot of individual people who are going to be involved, or even individual churches. I just don't think that they have the resources or expertise to do that. But if you are talking about something on a local level, you could certainly have hearings, public hearings. That is a much more accessible way of getting participation as opposed to the Federal Register. I guess the other thing I'd say about notices in the Federal Register is that I think, except for, I guess, the preliminary notice of rulemaking, and even there, I think that also suffers from what I'm about to say. I think most of those are drafted kind of at the end of, or released at the end of a process where the agency kind of knows what it wants to do. And, they're not going to be, I mean, it would take something extraordinary to have them fundamentally change their approach. So I think if you're going to have effective participation and effective informal participation that the agency actually wants to hear in terms of how it structures its thinking on a matter, it just has to be early in the process than the notice of proposed rulemaking, or even probably the preliminary notice of proposed rulemaking. And I guess you could have an advisory committee serve that role. Although I often think of advisory committees as these are the experts, these are the people who know, and we don't need anybody else because we've got everyone in the room who knows everything that needs to be known. And that may be, I may be mischaracterizing advisory committees, or if I am properly characterizing it, maybe it's a kind of foolish assumption for advisory committees to have. But my suspicion is that that's the way they function, at least in the United States, which is why they don't do a lot of. I don't think they do a lot of outreach.
We did not. I was on the National Academy of Sciences Institute of Medicine Advisory Committee. We did not respond in that way. We did like 2 years of information gathering.
Oh, okay.
So that was my one experience. So I don't know.
Oh, okay. So I may be completely wrong, but just kind of looking at the results of various advisory committees and how they've operated, they don't seem to have a lot of a big outreach component.
No, there's no outreach component.
Yeah.
There's a lot of information gathering and bringing in people from different expert kind of areas. So, so it's not outreach to communities, and that's something that I was critical of, because EU does seem to do that with their advisory committees. But there is an outreach component in the sense that there's a lot of bringing in folks, and the people on the committee suggest different experts to bring in and community members to bring in. But it's not.
So they're bringing in more experts, though. So
Right,
it's
right.
like, okay, they're experts, they're bringing in more experts, but
Sometimes it'll be experts in different populations, so like
okay,
community outreach experts, but it's much more separated from actual lay people. You're right.
right.
There's
So,
also another tool. I'm sorry, Renee. There's
Go ahead.
also another tool. I mean, Bernie, I totally agree with you. So there's another tool, which is, they're called public meetings, and they're sort of a hybrid. And what you're able to do, and they've increased in frequency in the wake of the drug safety issues in the early 2000s, because what the agency realized and what Congress mandated was the need to actually try and hear more from patients, and despite all the barriers that we've talked about. So what these public meetings do is they allow, a docket is set up that would feed into the rulemaking process, Bernie, at an earlier stage, because you're right. Once that die is cast, I mean, there are some agencies who pretty much the proposed rule is, this is what the final rule is going to be, unless you argue something compelling that causes me to change, which, that's not. But these public meetings are geared towards trying to bring in folks who aren't a part of these larger stakeholder groups, and with an eye towards really understanding the patient experience, so that it better targets the agency's drafting of some of these initial guidances and Federal Register notices. So that's a tool that people are trying to refine, and they actually have public meetings now for specific diseases as a part of trying to refine, and that's what I was alluding to as maybe a possible tool going forward, to look at specific diseases that affect certain communities. Again, still fairly new. The agency is still working on it, but the point is that it works at a stage in the rulemaking where it might be possible to have more of an impact than just responding to the proposed rule, which that by that time.
Yeah.
Well, so a couple of things though that, and again, this is probably another area where what I'm about to say is not representing the section's views, but the federal APA has no contemplation of the advance notice of proposed rulemaking that Bernie was talking about.
Yeah.
But a lot of agencies, my experience with the rulemaking process when I was in the government, indicated that a lot of agencies in fact do go out and try to elicit comments from expert communities, but also some of the affected communities before they announce a rulemaking either at the proposed rule level or previous to that, eliciting ideas about the rules, so that there is something besides what's going on internally in the agency to inform what the rulemaking process is going to be about. And so the statute, right, could actually do more to encourage that sort of activity, or any of these outreach efforts that we're talking about. And then, of course, the Section 553 famously does not require any kind of oral hearings or anything like that in response to rulemakings. Now, you don't want to burden, some, super technocratic rulemaking process with, all kinds of oral proceedings that arguably are not necessary or helpful. But that does send a message that this is really a technocratic process, and the views of people who aren't playing regularly in that sandpit are not welcome. So one could think about what kinds of whether we could do more even with it, either change the statute, although that seems very problematic these days, change any statute, but or to really provide incentives for agencies to engage more in that outreach kind of effort. I think John, mentioned, some of the drug safety issues, and I don't know if you were, I think you're probably talking about something like Vioxx or something, or, but also, the issues that have come up with the opioid epidemic, which was our previous epidemic, that was really, I still think that in some ways the medical community has gotten off a little lightly for its role in that whole problem. And there was a recent piece in the New England Journal of Medicine, which identified several areas of medical practice where race was a component of the algorithm for determining treatment protocols. And the the point of the article was that race was hardly ever relevant in these specific instances, and in fact, often led to disadvantaging patients of color because it sort of downplayed their symptoms, their test results, and therefore delayed access to more aggressive treatment. And one of those areas was kidney disease, right, which is a significant problem in the African-American community. And so, there's an effort now to kind of re-examine all of those algorithms that is, I think, actively underway. But I think that we all, in what we do, have to kind of re-examine these things that we just sort of like take for granted. Oh, this is what I was taught, and this is so how we go about it. And really try to, think anew about what really makes sense in some of these situations. The other thing I wanted to say about advisory committees is that I'm in the process of perhaps getting on one now from the NAS. And, obviously we don't want people with blatant conflicts who will be able to, sort of infuse their self-interest into these processes. But at the same time, that then you end up with people who actually really don't know so much about the issue. And, so my advantage is that I know enough just to be dangerous, but not so much that I have terrible conflicts, but in this particular thing. But, and so when I think that broader public participation in the process on the public record would perhaps alleviate some of those concerns about conflicts that, that affect the structure of these advisory committees.
So I think that's right. So when I was commenting on Steph's point, in regards to FDA advisory committees, keeping them staffed with adequate personnel is a challenge, even before you get to the broader representation, for all the reasons that you stated. And they're really important to the agency because the agency is never going to be able to hire folks who, have all those scientific perspectives that reside in the outside world. It's a very important role. And yet, if you follow closely, you'll notice there's always a challenge to staff them. And so I think one of the ways to get around that is full transparency regarding people's background. So you can weigh that as part of, analyzing their decision or the reasons for that decision, because I just think this is not a problem that people have been able to solve. And I would argue, as some of these products become continuing more complex, whether it be medical devices, drugs, or whatnot, the need for outside support and help is going to be even greater. And so I just think, Renee, that is something that, in my humble opinion, should be considered in order to ensure that we have the proper staffing of these committees and that we can also broaden the representation of them.
I know there's been a really robust and rich chat discussion going on as we've been having our conversation. So I hope that we're able to capture that so all of us can take a look back at it afterwards and have access to some of the resources that have been posted. And I want to say that we probably will have time for a couple questions from the chat more directly at the toward the end. But I wanted to ask one other question about this before we move on, perhaps to maybe some more audience questions, which is, several of us teach administrative law. All of us have gone to law school, and all of us work in this area. Why do you think that, articles, administrative law, until fairly recently, has not really embraced this line of inquiry as enthusiastically as it might have? And is there something, what should we do as law professors or people in the profession who think about these issues to try to, broaden the educational experience of law students as they consider these issues while they're in school?
Well, difficult question. And I do talk about this in my piece and have kind of thought further about it since the piece. my take on it is, and I may be just extrapolating from myself, but my take on it is that often in administrative law, what we're trying to do is come up with somewhat neutral principles that don't depend on which ideology you have. And so there's certain aspects of process and aspects of restraining agency arbitrariness that I think we like to try to approach at least from an ideological neutral perspective. And I think that gets in the way of thinking about procedures in terms of certain substantive impacts, like the impact on racial justice. And can you have an administrative law that is purely procedural, is purely neutral principles? I think you can't. I mean, I think invariably the principles are going to affect the substance. And for instance, the law of standing has all sorts of substantive consequences, even though it's kind of framed in a neutral manner. It's not really neutral. So what, and I mean, there are other things. I mean, if the, and this is not quite the question you asked, but the question is, what do we have to say about the controversies over the summer with regard to the police and with regard to George Floyd and Breonna Taylor, right? Part of the answer to that is that there are some processes that take place without the opportunity for higher level review, right? So in administrative law, we tend to focus on how that higher level review takes place. What are the processes for that higher level review? I think, not that we have nothing to say about purely discretionary actions of low level employees, but I think that is not the strength of our theories of administrative law. So I think those are kind of some of the issues for why I don't think we focus adequately on racial justice. That being said, I think that, I mean, the obvious answer would be we need to strive to look for areas in which racial justice issues are involved in administrative law and introduce those to our students. And in some ways, the color blindness of administrative law cases, I mean, if we're going to teach from a case basis, it's, I don't know, I've found it actually hard to find out sometimes what are the race of the participants in administrative law case, or what are the racial justice issues involved. So that we're lucky to have Peter Strauss, who can tell us what the racial impact was with regard to Overton Park, right? But that's not actually, in my experience, often easy to kind of pull out of cases. So I think that's an obstacle, but I think that is at least one direction to go and look at some of these things, like how's the FDA deciding how to distribute vaccines. Put administrative law in that context and look at efforts to deal with racial disparities in that context.
Well,
So
and then school discipline area is one obvious one, because there's this one case that, we all know, Ingram against Wright, and, the racial content of it is not well known. Obviously there's been a lot of research on that issue recently and the disparate impact in school discipline matters. Steph, do you want to add anything on this question?
I feel like I'm really lucky in that I teach at University of Wisconsin, where we actively promote what's called a law and action approach towards teaching. So we're all encouraged to always talk about not only the substance of the law, but also how it actually plays out with respect to various communities, because we also like to think of ourselves as kind of a societal law and society school. So, so I get to talk about that all the time, and I have been talking about that. For example, just even teaching the doctrine of exhaustion, right? You can sort of look at the doctrine of administrative exhaustion, but then you can apply it in different contexts where it's just impossible, right? For folks to know how to get past that, right? So I'm thinking of like prison sort of appeals and stuff. So how can you know if the process itself is so Byzantine that you never quite know whether or not you've exhausted your administrative remedies or you've gone past the time, then you do often get very disparate impacts on the kinds of people who are able to raise claims in the context of a prison. So I get to bring up this kind of stuff, and I think the students like seeing that. It does, it's pretty consistent with our whole approach to teaching at my school. So I've really only taught at my school. So I think I've been shielded from the, okay, must focus on procedure approach that I think many of the administrative law professoriate have had. That said, I think there is still, in terms of attracting people of color into the practice of administrative law, I think it's hard because it sounds boring, right? You got a name, administrative law, which is already making people yawn. And I think that one of the things to do is to sort of actually coordinate better, and I've been trying to do that with faculty members who teach in different substantive areas of law so that they can emphasize how administrative law is relevant for on the ground things, because students, I think, need to hear it from those professors as well.
Yeah, and I think sometimes, coordinating with the clinical programs that we might have at our schools, see some of these cases in action. Like, for example, in addition to administrative law, I teach health law. We have a health law clinic that actually takes a lot of Social Security disability appeals cases, right? And so, the students actually do get to see, what some of the challenges are that those populations face in trying to secure benefits. And actually, if, bringing that subject having come up, if you think about the Matthews against Eldridge case, for example, and compare, on the Social Security disability benefits, I usually do a big introduction about, who is the population of Social Security disability beneficiaries? What is the average monthly payment? Because the court makes this whole big production of saying that, oh, well, the amount of money, these people are not relying on this money for their livelihood. Well, yes, they are actually, in fact. And so it was this big, kind of obfuscation of how important these benefits were that, led to, the court, to, be able to decide, well, we don't have to have pre-termination hearings because these people really don't need the money. And that's just, not true. So I think that really, that kind of, the ability to do that kind of thing is really important. There was one other thing, Steph's, referring to her own school reminds me of another organization that I do a lot of work with, which is the National Academy of Social Insurance, which does research on, Social Security and Medicare, workers' comp, unemployment compensation. And we have a study panel going on right now that I'm co-chairing on, we're calling economic security, which is thinking about, things like universal basic income by another name. We're calling it assured income, and how to sort of reinforce some of the other, economic security aspects of the social insurance infrastructure. And we actually and we usually, sit around and, talk among scholars about all these issues. And we decided for that one, that we actually really did need to go out and try to talk with some, at least some organizations that represent the populations that are served by these programs. And that has been, I think that's going to make a huge difference, really enrich the quality and the content of our final report, because we did that. And so I think it, it can be overstated that, asking people who are participating in these programs, what they think about them is a very important part of the process that's often overlooked. I am not seeing any direct questions from our audience. Is there anything in the thread? I know Steph has been responding in real time, and I'm not able to type think and talk at the same time. So, and I don't know if you saw anything that you thought we should address, or John has another comment.
I don't have Steph's capabilities either. First of all, I would have loved to have Bernie or Steph as my administrative law professor. But one observation I wanted to make: when I went to law school at the time, there was a lot of impact on a lot of discussion of the impact of the legislative branch and driving change through. But to be perfectly honest, over the last 15 or more years, there's been a great deal of inactivity in regards to the legislative branch. And I think maybe for all of us, helping students understand that where the rubber meets the road is really the executive branch these days, and understanding the administrative process, maybe that will help change some perceptions as well. FDA gets new legislation every 5 years, and in many cases, Congress just sort of defers to the agency on how it gets things done because of the scientific complexities, which puts it squarely in the hands of the executive branch. ACA was the same thing. I mean, over 1,000 references to discretion of the secretary. So my only point is, I think sometimes students don't appreciate how big impact they can have across all of our lives by understanding the administrative law and becoming well versed in it. So.
All right, so one leading edge question, and then maybe this will be our last question and we will conclude because we're at the time. But we actually, the questioner wanted asked the panelists to comment on the the recent executive orders from the president about training in race, systemic racism, implicit bias training in federal agencies and for federal contractors, and the critiques embedded of the critical race theory. Do we think that is going to continue to have traction after the transition that most people anticipate on January 20th, or what do you think about that?
No, I don't think it's going to have traction, and it's it's one of the ideas that really doesn't make a whole lot of sense, frankly. But I think, it just doesn't make a whole lot of sense for many of the reasons that we've been talking about on this panel. That is one way to get more participation from people of color in terms of grants, in terms of advisory panels, because we tend to, in decision making, we often tend to replicate ourselves. And if you can get people at least to think about, well, I kind of am replicating myself in a way that has certain biases, then obviously you want to do that, it seems to me.
I think it's an example of what I was talking about earlier of, trying to pretend the problem doesn't exist and then, hoping that therefore it will go away or not ever emerge. So I do tend to agree that I think that will be something that's early on the chopping block, in a Biden-Harris administration, and something that can be dealt with, right, by and large on day one, because it was done by executive action. All right, well, thank you all so much for this really rich and enjoyable conversation. I think that it was, challenged us to think about the ways in which race embeds itself in, the actions and the decisions of administrative agencies. And also, we did talk about some possible paths forward to trying to make sure that that we take this moment as an opportunity to try to rethink about how we teach administrative law and how we practice it, so that we have some possibility of addressing these issues and having the policies of the government not reinforce the biases that have plagued the nation since the beginning. And I think that I just wanted to close with a poem. I know that seems a little, not quite at the level that we've been talking about, but there's a great Langston Hughes poem about why it's important to try to think about these things. It's sort of like why it's important to think about encouraging people to participate in these processes that involve decisions that affect them. It's that, that if we don't do it, then our optimism and our view of possibilities for the future are not possible to hold on to. And the poem is called Hold Fast to Dreams, and it's very short, so I'll just read it very briefly as a way of providing some concluding thoughts to this conversation today. Hold fast to dreams, for if dreams die, life is a broken winged bird that cannot fly. Hold fast to dreams, for when dreams go, life is a barren field frozen with snow. And what we want to think about is how the government and the administrative process provide the possibility for making opportunities for all Americans. And that's, I think, why it was important to have this conversation today. So thank you all very much. And thank you all to our participants. And I can't wait to take a more careful look at what was going on in the chat while we were all talking. Have a
Thank you.
Good thanks and safe Thanksgiving holiday, everyone.
Thank you.
Thank you, everyone. You were wonderful.
Take care, everyone.
Bye, Ann.
Bye.
Bye.